Judgment in the matter of the reference by the Attorney General for Northern Ireland, Abortion Services, Safe Access Zones, Northern Ireland Bill.
Under the Northern Ireland Act of 1998, the power of the Northern Ireland Assembly to make legislation is limited. A provision of a bill is outside the Assembly's legislative competence if it is incompatible with any of the rights protected by the European Convention on Human Rights. The Act also enables the Attorney General of Northern Ireland to refer to this court the question whether any legislation passed by the Assembly is outside its legislative competence. This reference concerns a provision of the Abortion Safe Access Zones Northern Ireland Bill, which was passed by the Assembly in March of this year. The bill is designed to protect the rights of women to access abortion and associated health services. It prohibits protests and other specified behaviour within what are called safe access zones around abortion clinics and related premises. Specifically, the reference concerns Clause 5.2a of the bill, which makes it a criminal offence to do an act in a safe access zone with the intent of, or reckless as to whether it has the effect of influencing a protected person, whether directly or indirectly. The persons protected by Clause 5.2a include patients, persons accompanying them, and staff who work at the premises where abortion services are provided. The attorney is concerned that because Clause 5.2a does not provide any defence of reasonable excuse, it disproportionately interferes with anti-abortion protesters' convention rights to freedom of thought, conscience and religion, freedom of expression, and freedom of assembly. Before considering that question, the Court considers some questions arising in this case from the judgments in two previous cases. It holds that during a criminal trial relating to protests, it is not always necessary to assess whether a conviction for an offence would be a proportionate interference with the defendant's rights under the Convention. The ingredients of an offence can in themselves ensure that a conviction will be compatible with those rights. This may be the case even if the offence does not include any defence of lawful or reasonable excuse. The Court also holds that the assessment of whether an interference with a convention right is proportionate is not an exercise in fact-finding, but rather involves the application of a series of legal tests in a factual context. As a result, it does not necessarily need to be conducted by the body responsible for finding the facts at any trial. The Court then turns to the question referred to it by the attorney, namely whether Clause 5.2a is outside the legislative competence of the Assembly because it is incompatible with anti-abortion protesters' convention rights. The Court unanimously holds that Clause 5.2a is compatible with the convention rights of protesters and is, therefore, within the legislative competence of the Assembly. It recognises that although not all protest activities are protected by the Convention, Clause 5.2a does restrict the exercise of protesters' convention rights. However, this restriction can be justified. First, the restriction is prescribed by law. Secondly, Clause 5.2a pursues a legitimate aim. It seeks to ensure that women have access to advice and treatment relating to the lawful termination of pregnancy under conditions which respect their privacy and dignity and are not driven instead to less safe alternatives, thereby protecting public health. It is also designed to enable staff who work at hospitals and clinics where terminations are available to attend their place of work without being intimidated, harassed, or abused. These aims fall within the qualifications in Articles 9, 10, and 11 of the Convention, which permit the restriction of rights in order to prevent disorder, protect health, and protect the rights and freedoms of others. Furthermore, the right to access health care in conditions of privacy and dignity and the right to pursue employment are protected by Article 8 of the Convention. There is a positive obligation on states to enable pregnant women to exercise effectively their right of access to lawful abortion services without being hindered or harmed by protesters in the ways described in the evidence before the court. Thirdly, the restrictions imposed by Clause 52A are proportionate. The aim of the clause is sufficiently important to justify restricting protesters' rights, and the restrictions that the clause imposes have a rational connection to that aim. The clause is not unduly restrictive, rather it is rational and necessary if the bill is to achieve its intended aims. A defence of reasonable excuse, in particular, would render the clause less effective. The clause itself strikes a fair balance between competing rights. In reaching this conclusion, the Court has regard to the following considerations. First, the context is a highly sensitive one in which the protection of the private lives and autonomy of women is of particular importance. Secondly, women who wish to access lawful abortion services have a reasonable expectation of being able to do so without being confronted by protest activity designed to challenge and diminish their autonomy and undermine their resolve. Thirdly, the bill only prevents protesters from exercising their rights under the Convention within designated safe access zones adjacent to the clinics and hospitals in question. They are free to protest anywhere else they please. Fourthly, the women and staff protected by the clause are a captive audience who are compelled to witness anti-abortion activity that is unwelcome and intrusive. Fifthly, the bill is intended to implement the UK's obligations under the Convention on the Elimination of All Forms of Discrimination against Women. Sixthly, the maximum penalty for an offence under the clause is a fine of up to £500. Seventhly, in a sensitive context like this one, states have a wide margin of appreciation in situations where it is necessary to strike a balance between competing convention rights. For all of these reasons, the Court is satisfied that the restrictions imposed by the clause are justifiable and that it is within the Assembly's legislative competence. The Court will now adjourn.